The top 10 things debt settlement companies cannot do to Texans. Hi, this is Consumer Protection Attorney Bill Clanton, and I've helped hundreds of consumers, that's regular folks like me and you, deal with inaccurate credit reporting, debt collection harassment, and other consumer-related matters. Now, this video is one of those consumer-related matters. It's not fair credit reporting, it's not debt collection harassment, but these debt settlement companies are just a bad lot, and they're so bad that in 2005 the Texas legislature made a law. That's Chapter 394 of the Texas Finance Code, and I'm taking a top 10 list out of that law of what these guys cannot do, and I've got a couple of bonuses after the top 10 list. Okay, the number 10 thing is require payment of an amount that the provider states, discloses, or advertises to be a voluntary contribution to the consumer. So they can't require a payment they're saying is voluntary. Okay, 10. Number 9, engage in unfair, deceptive, unconscionable practice in connection with their service. This means making misrepresentations to you, giving you other false information. Number 8, they cannot use unconscionable means to obtain a contract. That means they can't lie to you before you engage their services. They cannot make a misrepresentation about their ability to provide debt settlement services or other things. Okay. Number 7 is they cannot give you legal advice or represent that they can provide legal services unless they have an attorney and follow state bar rules. Okay, we're on number 6 now. Number 6, offer to pay or give a bonus, a gift, a premium, a reward, or other compensation for you signing up with them. They can't say that you'll get a toaster or whatever, a discount or anything for signing up with them. That's a pretty tricky one. A lot of these folks engage in that because it's a good sales tactic. They just can't do it. Okay, 5, they cannot engage in business with an entity like them prior to that entity being approved or without the consent of the commissioner. What that means is they can't, a startup debt settlement business can't turn your account over to another debt settlement business without the commissioner's approval, without the commissioner approving that type of activity. Okay, number 4, they cannot obtain a mortgage or other security interest in your property. They can't put a lien on your home. They can't put a lien on your car, anything like that. They can't have any kind of security interest or take a security interest in anything you own as part of their services. Number 3, they cannot lend money to you or provide you credit in any form. So they can't say that they're providing you credit. They cannot give you money. They're prohibited from doing that. Number 2, they cannot receive or charge a fee in the form of a promissory note or other negotiable instrument. They can't take out some kind of an instrument that you have to repay later. Okay, number 1 thing they cannot do is purchase your debt or other obligation. They can't buy your debt and then try to repay it at a lower amount or something like that. They are prohibited from buying your debt. That's the top 10 list. Now, a couple of bonus ones. They cannot have you waive your right to a jury trial. Yeah, you cannot be bound by an arbitration clause if you're going to sue them. So there's your bonus. There's your top 10. If you're dealing with these debt settlement companies, give us a call. They could be breaking the law. We want to get to the bottom of it. If they are, we can bring a lawsuit against them and hopefully get you some of your money back. We do this on a contingent basis, so we won't charge you anything to get started on your case. Give us a call. Hope you got something out of this video. If you did, please subscribe to our channel. Thank you for watching.